Hello, and welcome to Should You Incorporate Your Nonprofit Provincially or Federally? My name is Benjamin Miller, and I'm a lawyer who serves nonprofits and charities, and I'm of counsel with B.I.G Charity Law Group. First of all, I want to congratulate you on your endeavor to start a nonprofit. One of the earliest and biggest legal decisions you're going to have to make is whether you will incorporate, if you want to incorporate, under provincial laws or federal laws. So in this video I'll walk you through what those laws are and three of the bigger differences between the two laws, Ontario and Canadian law. There are other differences, and as I'll note on the next slide, this is just general legal information, so there are many other factors that might influence your particular decision to incorporate federally or provincially. So as needed, I encourage you to seek out a competent legal advisor. My contact information is at the end of this presentation, and you can also visit charitylawgroup.ca for help. I'll also note that I'm discussing these two laws as they exist now in October 2021. However, the Canada Not-for-Profit Corporations Act, the federal law, is under review, and so it may change in the coming years. Okay, so to begin, nonprofits in Ontario can choose to incorporate under the laws of Ontario or the laws of Canada. The name of the law in Ontario is Ontario's Not-for-Profit Corporations Act. I'll refer to it as ONCA throughout this presentation. And the federal law is the Canada Not-for-Profit Corporations Act, and I'll refer to it as the CNCA. So the first major difference has to do with who you want to have on your board. If you want to have ex-officio directors, these are directors who automatically become directors because of their office. So let's say you're a newspaper and you want the editor-in-chief to automatically be a director, or you are a church and you want the priest to automatically be a director. These are examples of ex-officio directors. Provincial law, the ONCA, allows for ex-officio directors, but the CNCA does not. So if that's important to you, that can be a reason to choose provincial law. Now, there are workarounds under the federal law, but it gets complicated. So if you want to avoid the complications, you may just go with provincial law to begin with. The second thing that might affect your decision when it comes to who you want to have on your board, if you're planning to have employees on your board and you're planning to either become a registered charity with the Canada Revenue Agency, so that would give you the power to issue tax receipts, or you're planning on getting $10,000 or more from either the government or people besides your members, so you want to fundraise to the public, then the ONCA says that you can have no more than 1/3 of your directors be employees. So if you're planning to have a structure where you're the only director and you're also the executive director and you're also the employee and so on and so forth, that may not work if you want to fundraise from the public or get government funding under provincial law. So you might tilt towards federal law. Under the CNCA, it says that you need at least 2 independent directors. So you still need to have other people involved, but you can have more employees on the board. So if employees on the board is important to you, that's a big difference. The next area where the two are different, this is probably the most significant difference, is in the financial review requirements. If you're planning on becoming a registered charity or getting more than $10,000 from public sources, then if you expect your budget to be less than $500,000, which is pretty reasonable if you're just starting out, then it'll be more lenient under provincial law. If you're not planning on becoming a registered charity or getting your funding from public sources, then the picture is a bit more complicated. If you're planning for a budget, let's say eventually down the road of $500,000 to $1 million, then as long as you can get unanimous agreement from your members, it's actually can be easier under federal law. But if you're planning ultimately for a budget over $1 million, ONCA will have the more lenient standard. So it really depends not just where you are today, but where you want your budget to be and what your membership structure is and whether you think you can get unanimous agreement. Finally, under federal law, if you're either a registered charity or getting money from public sources, you're going to have to file your financial statements with the government, which you don't have to do under provincial law. So those are just some of the differences. If you have any questions, don't hesitate to reach out to me at benjamin.miller@charitylawgroup.ca, or just visit charitylawgroup.ca and someone from the team would be happy to take your question. Thanks so much for listening.